Good morning. We're going to start as a subcommittee until the rest of the committee members here. Since we do have an author here, I want to welcome everybody to the March 1st, 2016 hearing of the Assembly Public Safety Committee. Again, we'll start as a subcommittee, and we do have an author. Mr. Bloom, will you please? Item 21, AB 1854, bail, attorney fees, forfeited bail.
Thank you. Good morning, Mr. Chair, and congratulations on escaping the Budget Committee. And good morning, members. Thank you all for your time. I'm very proud to present AB 1854. It's a straightforward measure that aims to relieve some of the financial burden faced by local agencies in litigating bail forfeiture cases. Under existing law, the California Superior Court is required to declare bail or the money or property deposited as bail to be forfeited when a defendant fails to appear for an agreed-upon court proceeding. The forfeited bail funds are then divided between cities and counties according to the penal code. Bail forfeiture is often followed by a counter motion to challenge the forfeiture. The defendant's bail bond agent can make a motion, and frequently does make a motion, to vacate the forfeiture and claim that various circumstances caused the defendant's absence, and therefore the forfeiture should not occur. A significant amount of time is involved in opposing these motions, and financially strapped local prosecutors, district attorneys, and county councils end up bearing the costs. Existing law under California Penal Code Section 1305.3 allows for the DA, county council, or prosecuting agency to recover out of the forfeited bail money the costs incurred in successfully, only when successfully, opposing a motion to vacate the forfeiture. So from 1994 to 2012, local government agencies successfully were able to recover attorney fees in bail forfeiture cases. However, a court case in 2012 entitled People versus U.S. Fire Insurance held that costs do not include attorney fees, but at the same time invited the legislature to specifically include attorney fees if, in our good judgment, we believe that's appropriate. The Court of Appeal stated that costs in California has only encompassed reporters' transcripts and filing costs, but not attorney fees. That was the basis of the ruling. So this proposal inserts attorney fees into statute to allow county councils and district attorneys to recover all of their costs, including attorney fees, after they've successfully opposed a motion to vacate a bail forfeiture. So, Mr. Chair and members, AB 1854 is a simple but necessary measure to address these overlooked costs and return us to the pre-2012 scenario. The LA County District Attorney's Office observed that given the financial constraints faced by our office, it is imperative that all deputies make every effort to recover attorney fees when they have successfully opposed a motion to vacate a bail forfeiture. Passing AB 1854 will ensure that local government agencies can recover a significant portion of their costs that would have otherwise been lost. I ask for your aye vote, and thank you for your time.
Thank you, Mr. Bloom, but before we move anything, we're going to establish a quorum. And
Jones Sawyer.
Here.
Melendez. Here. Lackey. Lopez. Lowe. Quirk.
Here.
Santiago.
We have three housekeeping items. AB 1571, Lackey, has been pulled by the author. AB 1745, Hadley, has been pulled by the committee. AB 1872, Gray, has been pulled by the author. And we have a consent calendar. Do we have a motion to approve the proposed consent calendar?
So moved.
Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, aye. Lackey.
Aye.
Lackey, aye. Lopez. Lopez, aye. Lowe. Quirk.
Aye.
Quirk, aye. Santiago.
Consent calendar is adopted, which makes this agenda much more manageable. Thank you. Now, I did hear a motion, and I heard a second.
Thank you. Mr. Chair, we have Dan Felizzato and Bill Woods here to testify in support of the bill.
Remember, don't talk past the yes.
Mr. Chairman, members, Dan Felizzato on behalf of the LA County District Attorney's Office. We are co-sponsoring this measure with the California State Association of Counties. This is a fairly straightforward bill, returns the law to its pre-2012 state. We simply ask for your aye vote, and I'm here to answer any questions the committee may have.
Thank you.
William Woods, Assistant Head Deputy District Attorney. Urge you to vote in support of this. It is a cost. We literally have to take one Deputy District Attorney out of the mix of the criminal enforcement system to put them into the bail court to handle these matters. And it obviously is a cost we'd like to at least partially cover.
Thank you. Are there any witnesses in support?
Sean Hoffman with the California District Attorneys Association in support.
Gail Stewart on behalf of San Diego County District Attorney Bonnie Dumanis in support.
Okay. Are there any witnesses in objection of the bill?
Yes, Albert Ramirez, General Counsel for the Golden State Bail Association. We oppose the bill because it creates a one-way attorney fee provision, which is unfair to the bail agents. We have to pay our attorney fees whether we win or lose, and we are worried that this creates incentives to litigate cases that should be settled. And also, I noticed that they say that this just restores funding. We don't agree with that because the appellate court looked at the legislative history and found that there was never legislative intent for an award of attorney fees under this statute, which is more than 20 years old. And finally, the remedy for the county council and the DAs is merely to go to their board of supervisors and ask for additional funding if that's what they need, not to change a statute that's 23 years old and create these perverse incentives. Thank you.
Thank you. Are there any other witnesses in opposition?
Good morning. My name is Jeff Clayton from the American Bail Coalition. One simple thought here is, and we're willing to work with all the parties involved, is I think there's a better way to allocate the funds. This bill doesn't touch sort of the corpus, the amount of money that's flowing. It just changes where it goes. And so I think there's a more elegant way to do that, and we look forward to working with the parties involved to see if we can achieve that solution. So thank you.
Thank you. Are there any other witnesses in opposition? Any questions from committee members? Mr. Quirk.
Yes, so it's been suggested that all the DAs have to do is ask for more money from the supervisors. Yes, I can see the smile on Dan's face. Our counties are tremendously challenged. They have many more responsibilities than they have abilities to work on this. It's just amazing what we're asking our counties to do. This is a small amount of money. If the bail bondsmen have good cases, they can bring them and they'll win them. Otherwise, I think this is an extremely appropriate incentive to make sure that the cases that are brought are good ones.
Okay. Thank you. Any other? Okay. You may close.
Thank you, Mr. Chair. We will, of course, continue to listen to and work with the opposition, and I ask for your aye vote.
The chair is recommending an aye vote. And as you heard, Mr. Bloom, the opposition is willing to work with you to come up with probably a more palatable solution. So I would suggest, as we move forward, that you do that. And so the chair is recommending an aye vote.
The motion is due pass. Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, aye. Lackey.
Aye.
Lackey, aye. Lopez. Lopez, aye. Lowe.
Aye.
Lowe, aye. Quirk.
Aye.
Quirk, aye. Santiago.
All right. Thank you, Mr. Bloom. Your bill
Thank
is
you.
out. Mr. Rodriguez. You have several. Several more than two. So you want to start with AB 1680?
Yes, that would be fine.
Item number 4.
Good morning, Chair and members. The proliferation of drones or inexpensive, easy-to-fly, remotely piloted aircraft that can soar thousands of feet high in the air and come equipped with powerful video cameras are rapidly becoming a hazard to our first responders. Recently in California, a pilot flying a helicopter with 7 firefighters on board who were battling a blaze threatening nearby homes saw a 4-rotor drone only 10 feet from its windshield. This forced him to make a hard left to avoid a collision about 500 feet above ground. AB 1680 makes it a misdemeanor to interfere or impede police officers, firefighters, and EMS personnel at the scene of emergency. The unregulated and irresponsible use of drones is placing Californians, our firefighters, and emergency response personnel in increasing danger. The effective regulation and oversight of drone use at the scene of emergency will save lives. By clarifying that this is a crime can be committed by the use of a remotely piloted drone, police officers, firefighters, or EMS personnel will be able to warn drone users they are at risk at committing a misdemeanor if their drone interferes with police, fire, or EMT's activities. This measure does not create a new crime, but clarifies an existing provision of law and has wide support from numerous law enforcement, fire, and EMS medical agencies. I respectfully ask for your aye vote.
Move the bill.
Second. And you have witnesses?
No, I don't think they showed up, no.
If they show up during this time, then, anyone in witnesses in support?
Good morning, Mr. Chair. Corey Salzillo on behalf of the California State Sheriff's Association in support of the bill.
Melanie Cuevas on behalf of DJI, the world's largest manufacturer of commercial and consumer drones, in support as well.
Thank you. Any other witnesses in support? Anyone in opposition? Any witness in opposition? Seeing none. Any members have any questions? Ms. Melendez.
Thank you, Mr. Chairman. So this bill, I support what you're trying to do here. My question, though, is it doesn't seem to narrowly define a drone operator who's not at the scene. Current law already addresses if someone is at the scene and is interfering with personnel trying to put out a fire or whatever emergency. But this, I'm just wondering if you're making an attempt to make sure it's very clear that if I am interfering with any type of emergency situation by use of a drone and I'm not at the scene myself, that's what this bill is going to take care of.
Correct. That's what we're trying to clarify and make that. So we'll make it more clarifying in the bill that specifically that's what we're trying to do.
So you're going to make some changes to make sure that that's clear? Is that do I understand that right? Okay.
Yes.
I thought so. I just wanted to make sure.
Yes,
okay.
For the record, yes.
Okay, thank you.
And we'll work with staff just to clarify that as well.
Anyone else with any questions? And I would suggest the same. The members had dinner with the governor last night, and the governor, we talked about the vetoes that he's done over time. And I know this particular issue he's vetoed before. And so I highly recommend that you speak with the governor's office, because he's willing to work with the legislature to solve problems. But he is not afraid to use the veto pen. I can let you know that now. And so by tightening up the language, I think, and working with the governor's office, not only will you get this bill through, but I think you may have a favorable outcome on the back end when you get to the governor's desk.
Okay, so, I'll plan to do that as well.
So I'm recommending aye with kind of the same concerns that Ms. Melendez expressed, and wish you luck. The chair's recommending an aye vote.
Thank you. I appreciate it.
Madam Secretary, call the roll.
The motion is due pass to appropriations. Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, aye. Lackey.
Aye.
Lackey, aye. Lopez. Lopez, aye. Lowe.
Aye.
Lowe, aye. Quirk.
Aye.
Quirk, aye. Santiago. Santiago, aye.
Your bill's out, Mr. Rodriguez. Now, AB 1705. Item number 6.
Thank you once again, Mr. Chair and members. AB 1705 reduces the likelihood that contraband will enter our local jails by simply allowing our law enforcement community to use body scanners during the booking process. My measure does not mandate the use of body scanners, but merely adds this new form of technology to the list of acceptable search procedures. This bill allows the booking process to be less invasive in cases where reasonable suspicion calls for a strip and body cavity search. The flow of contraband in our county jails poses a great risk to the health and safety of the individual, staff, and other inmates. AB 1705 will give law enforcement the ability to use body scanners to reduce this risk. This bill will update current law to reflect advancements in technology that will aid in the booking search process. Here with me today are Corey Salzillo of the California State Sheriff's Association and Lieutenant Wayne Illowit of the Los Angeles County Sheriff's Association to testify.
Good morning, Mr. Chair and members. Corey Salzillo here on behalf of the California State Sheriff's Association. I don't know that I could say it much better than Mr. Rodriguez does. We just intend to specify in statute that body scanners are permissible technology for when we are booking into custody misdemeanant or alleged misdemeanant or someone being booked for an infraction, which is pretty rare. The statute is very clear when you can and cannot do a strip search or a body cavity search, and we think that this technology, that body scanners are less invasive, certainly less intrusive than a strip search, and really even less intrusive than a pat down. I know that going through the airport, I'd rather put my arms up and do the body scan instead of being patted down. So that's kind of what we're talking about today. And as Mr. Rodriguez said, it's about inmate safety, it's about officer safety, it's about the security of the facilities. There are any number of daily transfers. I think Lieutenant Billowit can talk about what the case is in L.A., but just between the booking of individuals into the facilities and then the in and out to and from court, you have a ton of traffic, even in the smaller facilities, and so we just view this as a security measure. We'd appreciate your aye vote. Thank you.
Good morning, Mr. Chairman, members. Lieutenant Wayne Billowit on behalf of the Los Angeles County Sheriff's Department. We've used the body scanners for the arraigned, post-arraigned inmates, and it has been tremendously successful in reducing incidents of uses of force and other types of negative contact between inmates and personnel, just simply for the fact that we're not putting hands on people anymore. It's a smooth process. When you have thousands of people coming through daily from the courts to the custody situation, it really does help reduce negative contact between law enforcement, the personnel working in the jail, and the people in the jail. So we strongly urge your support. Thank you.
Okay. Are there any other witnesses in support?
Good morning, Mr. Chair and members. Sean Rundle with the California Peace Officers Association in support of the measure.
Thank you.
Hi, Darby Kernan with the California State Association of Counties in support.
Thank you.
Jonathan Feldman with the California Police Chiefs Association in support.
Thank you.
John Lovell, Association for Los Angeles County Deputy Sheriffs, California Association of Code Enforcement Officers, California Correctional Supervisors Association, California College and University Police Chiefs Association, Los Angeles County Professional Peace Officers Association, LA Police Protective League, and Riverside Sheriffs Association, all in support and in alphabetical order.
Long list.
Thank you. Are there any witnesses in opposition?
Good morning, Chairman and members. Dennis Cuevas Romero with the Hernandez Strategy Group here on behalf of the California Attorneys for Criminal Justice, regrettably in opposition. The CACJ has some concerns about the invasiveness of these searches for misdemeanants and folks that are in for infractions when they are often in for crimes that are not very serious, not involving weapons or contraband. We think that this lessens the current standard by lowering the need to have reasonable suspicion with articulable facts for these types of crimes. In addition, we are concerned about the body scanners themselves. We're not sure what type of image the body scanners produce. We're uncertain whether the body scanners actually produce a very graphic image, which could possibly lead to an unknowing basically a naked body search. In addition, we have some concerns about the retention of images of the body scanners. For those reasons, unfortunately, we're in opposition.
Thank you.
Micah Doctoroff on behalf of the ACLU of California. I would echo my colleagues' comments and just add that body scanners have been the focus of a lot of public debate in recent years. Chief among those concerns, as my colleague mentioned, are those related to the images produced by some of the scanners, as certain scanners, namely those that display a person's soft tissue, have the ability to produce strikingly graphic images of the person's naked body under the person's clothes. This type of scanner permits those viewing the image to see the searched person's private body parts, including the size and shape of the person's breasts and genitals, or evidence of a mastectomy. Given the graphic nature of the images produced by these scanners and the corresponding level of intrusiveness, such scans have been deemed virtual strip searches. As you can imagine, virtual strip searches are particularly concerning in the jail setting, where sexual abuse and harassment of inmates is unfortunately all too common. With these specific concerns in mind, the legislature has very carefully put strict limits and protections in place to ensure and declare that individuals who have been arrested for minor misdemeanor and infraction offenses are not arbitrarily subjected to unnecessary strip searches. Included in these protections are that under current law, any person who is present or within sight of an inmate during a strip search will be of the same sex of the inmate, and that the search would be conducted in an area of privacy. This bill provides no such protections. So unless these issues are addressed, we remain in respectful opposition to the bill. Thank you.
Thank you. Are there any other witnesses in opposition? Okay. Are there any questions from committee members? Yes, Mr. Cork.
So with regard to the opposition from the ACLU and CACJ, all of us, well, many of us will remember when machines that would give body images and look for contraband in airports came out. The first ones gave graphic views of the body as described by CACJ. These were X-ray backscatter machines, and they do give a graphic image. They were then replaced with millimeter wave machines. These have a much greater wavelength, and they don't give that sort of detail away. I am fine. I can go through an airport and go through the millimeter wave machine. I'm quite happy with that. And I'm fine with that for misdemeanors. For the backscatter X-ray machines, though, I think there's got to be protections there that are not, and a number of law enforcement agencies bought these machines at the time. I'm fine for using those under the circumstances where you would have a strip search. I'm not fine with using them routinely for anyone who comes in for an infraction. That's why I'll be voting no. I hope that you can correct this further down the line, and I can support the bill.
Yes, Ms. Lopez.
Yes, I also have a question. How the machine is going to work with the women that are pregnant? Is any plan for those?
Assemblymember, there's no provision in the bill that relates to that. Counties would be free to have policies. I know of one county that, in fact, has a policy that they don't scan inmates they know to be pregnant or that indicate that they are pregnant. They go through a process where actually before they scan any female inmate, they will ask if she is pregnant, and if she reports that she is pregnant, they will not scan her. And as a matter of course, this particular facility will, before introducing the inmate into population, they do a pregnancy test as part of the booking process, which is routine. And if she's not pregnant, then they will scan her. But if she is pregnant, then they won't scan through the machine in that particular case.
Thank you.
Are there any other questions from committee members? All right, Mr. Rodriguez, I'm kind of torn between safety and sensitivity, and I value both equally. Obviously, we need to be concerned about the safety of the officers. I would even say not just scanning misdemeanors. We should probably scan maybe even some of the sheriffs and make sure that they are also not carrying in contraband. So I'm not averse to screening, but I'm also sensitive to what you can possibly see. And since we do have the technology to actually deal with this in a manner where we don't infringe on anyone's sensitivity, if there's a way you can amend it or whatever, I think you would have a more favorable outcome, or you can address it in your closing. I'm doing a non-recommendation, letting the members on their own decide which way they want to go. So in your closing, if you can address the members' concerns, I think it will be helpful.
Okay. Well, in closing, I would look forward to working with the members and their issues and concerns. But more or less, this is just another tool for law enforcement to use as they process to book inmates. It's not mandated. It's just a tool to help them to address some of the issues. And I'm looking forward to working with members of the committee and of the opposition to see how we can make this a better bill and more acceptable. So with that, I respectfully ask for your aye vote.
Do we have a motion?
So moved.
Madam Secretary, call for the vote.
The motion is to pass. Jones Sawyer.
Not voting.
Jones Sawyer not voting. Melendez. Melendez aye. Lackey. Lackey aye. Lopez. Lopez aye. Lowe.
Aye.
Lowe aye. Quirk.
No.
Quirk no. Santiago. Santiago aye.
That measure passes. Your bill is out. And one more, 1769. Mr. Rodriguez.